All, what the record showed
Hold on a minute.
for attendance, Supervisors Cassiola, Savavic, Fisher, Cowden, and Gizio are in attendance. Also, Bruce Bosley, our planning director, Chris Volz, our solicitor, and Dawn Janus, our manager. And before we get started, we need to have anybody who plans on giving testimony be sworn in. If you please rise and raise your right hand. Candy.
Each of you do solemnly swear the testimony you're about to give in this trial to be the truth, the truth, and nothing but truth, self you got.
Thank you. That is really... we're having this hearing, an additional hearing on this based on information we received at a prior hearing. We had testimony that made us reconsider some of the items that were included in that ordinance, and we made some adjustments so that we consequently was considered as a major change. So we have this additional hearing. Chris, do you want to just highlight those changes we had?
Yeah, I'll be happy to, Mr. Chairman. These are much more powerful than the old ones. What we did was we amended section 913F1 with respect to vacant lots. Previously, we required 51% approval to change a land use category for a vacant lot. In addition, now we will allow an applicant to present a petition and demonstrate compliance with the 402E and 402F factors. These are the standards for rezoning applications elsewhere in the ordinance. For developed lots, for a request to go to a more restrictive land use category, the board will evaluate such a request under the conditional use factors. If to a less restrictive land use category, the board will analyze the request under 402E and 402F, again, the rezoning application factors. And for a less restrictive land use, not a land use category, but a land use, again, the board will consider such a request under 402E and 402F. And if you make a change, if the ordinance clarifies that if you're making a change to a more restrictive land use, there is no need for an application or board approval. And the waiver section giving the board the option to waive these requirements upon submission of the consent of 100% of the adjoining landowners remains in this ordinance. One other change with the exception of recreational facilities, this ordinance does away with categorizing or putting into a level land uses. So recreation facilities are still the most restrictive land use, but everything else in residential is on the same level playing field as are all commercial and industrial uses. And that is a summary of the changes. I believe we've provided a copy of the ordinance to everybody, and the advertisement also contains a summary.
Chris, in a nutshell, it basically made it a simpler process if it's a more restrictive use, and it kind of geared towards zoning, the typical zoning request change if it's a less restrictive use. That's the... Exactly.
Land use categories are a zone within a zone, so we've decided that we should treat them as zoning changes.
All right.
To that standard.
I know everyone who has an interest in proceedings here tonight, you're aware of all that, so I'd like to open up the floor for any comments that anybody has.
Thank you. Maureen Sweeney on behalf of the Southpointe Golf Club. We have some binders with some exhibits for the board to consider as well. I'm sorry, let me make sure everyone can hear me. It actually works better if you hold it. At the outset, we simply want to say that, note that this latest draft unfortunately only reemphasizes the point that this proposed amendment is unfortunately targeting the Southpointe Golf Club property and is effectually rezoning the property to limit it to its current use, treating this property completely different from all other properties in the SD district without any valid rationale. And this kind of disparate treatment is the heart of our objection because it's clearly spot zoning. At the outset, I do want to note a couple of procedural issues. We'd also believe that the procedural advertisement or the procedural items leading up to this hearing are inappropriate. There haven't been sufficient notice given under Section 609 of the MPC. Because this is a rezoning of the golf course property, eliminating 52 uses to one single use. The MPC Section 609B1 and B2 require the property, the affected tract to be posted, as well as notice of the public hearing mailed at least 30 days prior, neither one of which has been met prior to this hearing. In addition, we would submit that the summary that was advertised in the paper was deficient. Section 610 of the MPC requires that the publication provide either the full text of the ordinance or a reasonable summary, and unfortunately the advertisement is at variance with the text of the ordinance in a couple of key places. In particular, the summary states that Section 4 of the proposed ordinance states that if any part of the proposed ordinance is declared invalid, such holding shall affect the validity of the remaining portion of the ordinance, which is the exact opposite of what's in the ordinance text that was made available at your office. And then secondly, the summary claims that the proposed ordinance deems all commercial uses and industrial uses to be equally respective, but in fact, the text of the ordinance that was made available to the public only indicates that all residential land uses other than outdoor recreational facilities are equal. It doesn't discuss commercial or industrial land uses or their severity or ranking. And so based on that alone, Section 610 compliance is mandatory, so any action on this ordinance would be null and void based on procedural bases alone. With regards to the exhibits that were handed to you shortly, just briefly, Exhibit 1 is excerpts from the Unified Development Ordinance that was in effect prior to the May 2nd amendment. Sections 202, the definitions, Section 402, Section 403, and Section 913 dealing with the Special Development District. Exhibit 2 is the ordinance that was known as number 1 of 2016, which was voted on May 2nd, 2016. Exhibit 3 was the proposed ordinance that was considered at this Supervisors' July 11th hearing. Exhibit 4 is the ordinance that was offered by the township at a zoning hearing board hearing concerning the substantive validity of the 2016-1 ordinance. And Exhibit 5 is the ordinance that was made available to the public that was at issue for tonight's hearing. Exhibit 6 is the correspondence sent by my client to Bruce Bosley for requesting Section 109 notices with regards to any hearings or matters affecting the property. And Exhibit 7 is a copy of the transcript from the July 11th hearing that previously dealt with the earlier draft of this ordinance. Exhibit 8 is the July 18th zoning hearing board that I just previously mentioned. And turning to Exhibit 9, do we have that oversized? I have a blow up of that to make it easier for people to see. Yeah, that's fine. So if you turn that, the Exhibit 9 is a highlight of language from Ordinance 216.1, which set forth, oops, it's falling down, a hierarchy, sorry about that, a hierarchy of the residential uses for, under the amendment. And it shows that the very first, at the top, the most restrictive was the community or private membership outdoor recreation facilities. And then the rest are ranked in a tiered.
Maureen, hold on a second.
Yes.
Lock those legs down and it'll...
We can already see it, it's in our book, perhaps maybe the audio.
Sure, we can do it for the audience as well.
We have it right here, so.
So then, moving to Exhibit 10, that is the language of proposed ordinance which deals with more restrictive reviews under the current proposed. So it still calls out separately community or private membership outdoor recreational facilities, and then category B is all other residential uses. So you're even further showing disparate treatment and targeting the Southpointe Golf Court property, which is the only community or private membership outdoor recreational facility in the SD district. So if anything, this exacerbates the condition that we had previously raised concerns about. And notably, if you then turn to Exhibit 11, with regards to the new language for commercial use categories, it simply says all uses by right residential land use category shall be deemed the same severity. It doesn't discuss severity in the commercial use. Similarly, Exhibit 12, for industrial land uses, it says all uses residential land use categories set forth shall be deemed to be the same severity. So at this point, there is no discussion whatsoever in terms of severity or ranking one way or the other with regards to commercial or industrial uses. We simply have the artificial carve-out of the private recreational facilities and then everything else. So with that, I'd like to call Mr. Swisher up just to briefly go over some items for the board's attention. Mike, could you just briefly describe your affiliation, your background relationship with Southpointe Golf Club and the development of Southpointe overall?
Ooh, great. Can I hang out right here? Michael Swisher, and I have been involved with Southpointe since 1985 when I did the master planning with a firm I was a partner with called Team Plan in West Palm Beach, Florida. So really from the very beginning, the planning stages and construction began in approximately 1991. I've been there for both development of Southpointe 1 and Southpointe 2, including the golf course and the golf club and all the amenities that go along with that.
And you're here tonight as an authorized representative of Southpointe Golf Club, Inc.?
Yes.
So I'm going to ask you to turn to what we marked as Exhibit 13 in the binders. I think you have an oversized version. We also have a blow-up for the audience if they'd like. Could you explain generally what this is?
Well, this exhibit shows all of the properties of both Southpointe 1 and Southpointe 2. And there's about 599 acres of Southpointe 1 and then 225 of Southpointe 2. There's a cross-hatched area that represents the golf course properties. It's about 188 acres. In this particular exhibit, it shows the golf course properties as 11.1 through 11.10. Now these are designations that are used by the Southpointe Property Owners Association. They aren't the exact parcel designations you may see on the subdivision plan, but there are 8 individual parcels that make up this crosshatched area, which is about 188 acres. And you can see the golf course stretches pretty far from the north down to the south end of the project, and it abuts all the various types of land uses that are in the project. It abuts industrial, if you go down to parcel 57 where the isoplex is, and it abuts several office buildings as well as residential. So there are about 162 parcels in Southpointe that the golf course touches, and that includes residential, but all but 18 of those 162 are residential.